shoot the fleas off a dog's back at 500 yards, Tannen, and it's pointed straight at your head.
You owe me money, blacksmith.
How do you figure?
My horse threw a shoe. And seeing as you was the one that done the shoe, and I say that makes you responsible.
Well, since you never paid me for the job, I say that makes us even.
Wrong! See, I was on my horse when it threw the shoe, and I got thrown off. And that caused me to bust a perfectly good bottle of fine Kentucky red-eye. So the way I figure it, blacksmith, you owe me $5 for the whiskey and $75 for the horse. That's $80.
Look, if your horse threw a shoe, bring him back and I'll reshoe him.
I done shot that horse!
Well, that's your problem, Tannen.
Wrong. That's yours. So from now on, you better be looking behind you when you walk, because one day you're gonna get a bullet in your back.
So we have Buford Mad Dog Tannen versus Doc Brown. Who's right? Who's wrong? It's another edition of Pop Culture Trials. Coming on up on Legal Bytes. So it's October, which means there are two things I personally love seeing on my TV screen right now. Dodgers baseball and the Back to the Future trilogy. I don't know quite what it is about Back to the Future. Maybe it's the fact that most of it takes place in the month of October, but every time this month comes around, I get an itch and I have to watch all three parts as close together as possible. Preferably all in one day. And it might seem like an inconsequential detail, but one of my favorite things about this trilogy is the fact that, unlike most other trilogies that are out there, each sequential movie picks up in exactly the same place as the previous movie left off. So when you watch them back to back, you really feel like you're watching one extended movie. If you're not familiar with the movies, they tell an epic story about a teen named Marty who lives in Hill Valley, California in 1985. He's friends with a local brilliant scientist named Emmett Doc Brown. And at the beginning of part 1, Doc realizes that he has finally figured out how to travel through time in a DeLorean.
This is heavy duty, Doc. This is great.
For the kids out there that don't know, the DeLorean was a sports car and the only automobile manufactured by the DeLorean Motor Company. It was known for its stainless steel finish and its iconic gull-wing doors. It was beautiful, but its life on the American auto market was short-lived and lasted only from 1981 to 1983, since apparently DMC filed for bankruptcy in December 1982. And apparently the car actually had a reputation for poor build quality, as well as for, well, disappointing power performance. But none of that matters if it has a flux capacitor and enough plutonium to set the world on fire. Obviously. I personally wasn't alive during the production of this car, but I did happen to see one as a kid in a supermarket parking lot one time. My brothers and I were like, oh my god, they're time traveling. Like literally, the association between DeLoreans and time travel was so strong, and the car was so rare growing up that I literally thought that if you actually saw a DeLorean, it probably was a time traveling machine. And then I just spent the rest of my life wishing that was the case. Anyway, so Marty and the iconic DeLorean travel back in time, then back to the present, then back to the future, then back to the past, then way back to the past to finally get back to the present. Make sense? Maybe makes more sense than Tenet? Don't get me wrong, I love Christopher Nolan and Inception is one of my all-time favorite movies. But Tenet was almost great. But in my opinion, there were some crucial scenes that kind of needed clear dialogue in order to continue understanding what was going on. Anyway, that's a total digression. Getting back on track, Back to the Future did not have that problem, and it's a thrilling adventure of a popcorn flick. Anyway, the bit that I want to talk about in this video is part 3, where a dispute arises between Buford Tannen and Doc Brown. So here's how we'll go about it. First, we'll do a quick summary of the relevant storyline for context, then we'll do the analysis for it, and then I'll give a verdict. Obviously, a spoiler alert is always necessary, even when we're talking about cult classics like this one. So I will give you 10 seconds of kitten and or puppy footage, depending on whatever we decide at the editing stage, so you can decide if you want to keep watching. Starting now. So as I said a minute ago, Back to the Future starts in Hill Valley in 1985. Marty, the main character, is a teenager with hopes of one day becoming a rock star and marrying Jennifer, his high school sweetheart. Marty has a late-night arrangement to meet up with Doc, the brilliant and eccentric scientist hell-bent on figuring out the great mysteries of the world, like time travel. And women. During this late-night rendezvous, Doc runs what proves to be a successful first test run of the time-traveling DeLorean. Marty learns that it's a completely electric automobile that merely uses a bit of radioactive plutonium to give it the kick to jump through time once the vehicle hits 88 miles per hour. Then, when Doc is about to time travel himself, they get attacked by members of a Libyan terrorist organization whom Doc happened to have ripped off in order to get the plutonium for the DeLorean. Doc gets shot, and Marty jumps in the DeLorean to try to get away. He's chased around by the terrorists until he hits 88 miles per hour, which sends him flying to the Hill Valley of November 5th, 1955. Throughout Part 1, a series of problems arises, requiring Marty to figure out how he's going to get himself back to 1985. At the same time, he has to try not to disrupt the space-time continuum by doing things like preventing his parents from meeting and falling in love. To do so, he finds the Doc that was living in 1955, and together they work out a solution to get Marty back to the future. While working that solution, Marty learns that his dad was a peeping Tom, gets into scuffles with his dad's bully arch nemesis Biff Tannen, kisses his mom. I mean, there's context, but it's still kind of weird. And then rocks out on his guitar at the school dance before speeding back to 1985. Once he gets to 1985, Doc comes in and scoops up Marty and Jennifer and says he needs to take them to October 21st, 2015 to prevent something terrible from happening to their kids.
Hey, Doc, we better back up. We don't have enough road to get up to 88.
Roads? Where we're going, we don't need roads.
Because you know, the DeLorean flies now. Okay, because I don't want to go over all the details here, I'll skip ahead a bit. Anyway, a bunch of stuff happens in 2015, and then Doc, Marty, and Jennifer go back to 1985, but they realize it's an alternate 1985 where everything is awful and no one is happy but Biff, who's now mega rich and worse than before. So to get everything back on track, Doc and Marty realize that they need to go back again to 1955, where a bunch of other stuff happens and they dramatically succeed at fixing the problem. And then just before Doc and Marty are about to come back to 1985 again, Doc is in the DeLorean in the air and Marty is on the ground and the DeLorean gets struck by lightning. Doc sends a letter through Western Union to meet Marty moments later. The letter explains he's really happy in the Old West of Hill Valley, and he tells Marty where to find the DeLorean as well as how to fix it. And he gives Marty explicit instructions to just leave Doc behind and to go back to 1985 and live the rest of his life. Marty decides otherwise, however. You see, he realizes that just 1 week after the date of the letter, Doc dies. He was apparently shot by a man named Buford Tannen, also known as Mad Dog, over a matter of $80. So instead, Marty goes back to 1885 and looks for Doc so he can prevent his untimely demise. Marty unfortunately meets Mad Dog Tannen first and gets saved by Doc just in the nick of time. Okay, so now that we're all caught up and on the same page here, we can get into that $80 dispute and unpack it through a legal perspective. Also, before people drop into the comments with things like, "This was the Wild West, there were no laws here," let me just get ahead of that and say, nope. That's not true. There definitely were laws. There were marshals, just like Chief Marshal James Strickland, and if you think about it, it would be pointless to have a marshal if you don't have laws to enforce, right? Beyond that, even if there wasn't a resident judge in that particular town, there were often in those days traveling judges who would travel from town to town and resolve the disputes that come up over time. So even if we don't see a judge in the movie, we can rest fairly easily with the likelihood that there probably is a judge somewhere nearby that is a traveling judge that can come around and eventually look at the case and resolve the dispute. Okay, with that part taken care of, let's get into the dispute. Okay, so the dispute starts with a horseshoe. Buford Tannen apparently went to Doc to shoe Tannen's horse. The horse threw the shoe, so Tannen now wants restitution. Specifically, he wants $75 for the horse that Tannen shot, and $5 for a bottle of whiskey that was lost when Tannen was thrown from the horse. So we first have to start by characterizing the legal issue here. In other words, we need to determine what area of law it falls under. Basically, there are two ways of looking at this dispute, as either a contract dispute or as a tort. The reason why it might fall under contract law is because we have an agreement between Doc and Tannen. Although Tannen allegedly didn't end up paying Doc for it, ostensibly the agreement was that Tannen would pay Doc to provide a service to Tannen, namely shoeing Tannen's horse. That agreement is also known as a contract. So we can probably say that because this agreement is at the center of the dispute, this is going to be governed by contract law. But before we move on, let's first consider the possibility that this is a tort. In addition to being the name of a tasty dessert, in the legal context, a tort is defined as a civil wrong that causes a claimant to suffer loss or harm. That's admittedly a really broad definition, so basically think of torts as falling into one of two main categories: negligence or intentional torts. Intentional torts are pretty easy to understand. It's things like assault, battery, arson, theft, invasion of property, anything that a person does to harm another person with some level of conscious decision. A lot of intentional torts are also actions that can be pursued as crimes, but because Marshall Strickland doesn't appear to be involved here, we don't really need to look very far into criminal law, and instead we can just focus on the tort contract law aspects. The other main category of torts is negligence. Negligence is basically where a person fails to act reasonably and in doing so ends up hurting someone else. Think of it as someone's carelessness leading to someone else's harm. Negligence can either be an affirmative bad act or it can be a failure to act when the person otherwise had a duty to do so. Examples of negligence are things like driving too quickly and getting into an auto collision, or failing to maintain a firearm in a safe or otherwise with other safety precautions. So which area of law does the Tannen-Brown dispute fall under? Contract law or torts? Well, in all likelihood, if this were a real lawsuit, Tannen would probably allege both as alternative theories of liability. Doing so would give him a greater likelihood of prevailing in case the judge or the jury isn't so convinced by one theory or the other. From the contract law perspective, it looks like the allegation is that Doc didn't perform a service that he promised he would. So if it falls under contract law, this becomes an issue of bringing the two parties into the position that they would have been had the contract been fully performed. That means that Doc properly shoes the horse for Tannen, and Tannen pays Doc for the service. Now, if Mad Dog asserts a contract claim, he actually has a problem. Technically, when it became clear that Tannen was not going to be paying for those services, he was actually in breach of the agreement. So even if he goes back to Doc complaining about the horse losing the shoe, he's going to have to pay Doc before he can get restitution for the allegedly incomplete services. So in that case, Doc technically doesn't have to do anything here, but he still offers to have Tannen bring the horse back so he could reshoe him. That is a pretty reasonable offer, I would say. Now, if Tannen had paid for the service and then the horse lost the shoe, and it can then be proven that the horse lost the shoe because of Doc's shoddy workmanship, because that's another important point. I admittedly don't know much about horses, but based on my basic research that I did on shoeing horses, horses can lose shoes for all kinds of reasons, even for seemingly no reason at all sometimes. But if Tannen can prove that it happened because Doc did a poor job of it, he would be entitled to go back and have Doc either perform a service to finish the job or to get money back in order to be able to get the horse taken care of elsewhere. But because he allegedly didn't actually pay for the services here, if this were a breach of contract claim, he wouldn't be entitled to any kind of damages. However, if Tannen asserts a tort claim against Doc, it would basically go like this. Tannen went to Doc to shoe his horse. Doc shoed it, but he did a poor job of it because he failed to take reasonable care in doing so. As a result of that failure, the horse lost the shoe, and at the same time threw Tannen off the horse. Now, it's important to note that Tannen doesn't assert that he was hurt in any way, but rather that a whole bottle of whiskey was wasted as a result. So there's no personal injury claim here, just the damage done to a bottle of whiskey. Is Doc responsible for the whiskey? Probably not. You see, when a plaintiff claims certain damages as a result of a defendant's wrongdoing, those damages have to be foreseeable. What that means is that they have to be the kind of damages that, in looking ahead before the incident ever occurred, they're the kind of thing that you'd fairly readily think about as consequences of that incident. So for example, damages in a case where someone was driving recklessly would likely include physical, mental, and emotional harms to a person who was hit by that vehicle. And if those damages to the victim are bad enough, sometimes the spouse of that individual can also come into the lawsuit and claim a loss of consortium. That basically refers to the deprivation of benefits of a relationship, and it includes household duties, caregiving, companionship, and intimacy. But if those physical, mental, and emotional harms led to a plaintiff's ultimate divorce and financial ruin, that might be a little bit too far off to claim as part of damages that a plaintiff can actually recover in a case like that. So in this case, when Doc is in his blacksmithing barn, putting a shoe on Mad Dog's horse, is it really understandable if someone were to say, hey Doc, make sure you do a good job of that, or else Tannen is going to end up ruining a whole bottle of whiskey when his horse ultimately throws him? Nah, that would require a little more context and explanation. Much more so than if you were to say, for example, hey Doc, make sure you do a good job of that, or else Tannen's horse is going to hurt him by throwing him, right? But obviously even that is assuming that a horse losing a shoe is the kind of a scenario that could possibly lead to a horse actually throwing the person off of it. Admittedly, I don't know enough about horses to be able to tell one way or another, and I couldn't find an answer from my basic internet research this morning. But either way, I think that there's just a little bit too much logical distance between a farrier/blacksmith shoeing a horse and a person on the horse then losing a bottle of whiskey to say that those damages are foreseeable. So that's that for the whiskey. What about the damages for the horse? Well, in any case, a plaintiff always has a requirement to mitigate his or her damages. That means that regardless of whether this case is litigated as a tort or a breach of contract claim, Tannen has to do whatever he can to make his situation better. To use an example from employment law, let's say that we have a case of blatant gender discrimination where an employee gets pregnant. Let's say she tells her boss the great news, and then the next day he turns around and fires her because he doesn't want the business to have to pay any kind of an increase in premium in health insurance after her hospital visit. Employment discrimination cases are rarely that obvious, but assuming it actually happened, that plaintiff would still have a reasonable duty to mitigate her damages by trying to find comparable work. Applying that here, when Tannen got thrown off the horse, he had a duty to mitigate whatever damages happened to the horse. Instead, he shot it. That's literally the opposite of mitigating damages. So Buford Tannen is probably not entitled to damages for the horse. And one last thing before we get to the verdict. The fact that Mad Dog's allegation wasn't personal injury, but rather a loss of whiskey is also interesting for one more reason. If you're familiar with this trilogy, you know that it really likes to mirror itself in a lot of ways throughout the three movies.
Hey McFly! Hey McFly! Hey McFly! I thought I told you never to come in here.
Something very familiar about all this.
It's almost as if it's trying to say that if you don't learn from history, you're doomed to repeat it. The claim about the loss of whiskey as a result of getting thrown off the horse actually kind of reminds me of one of the first scenes in part 1, where Marty comes home to find his dad had lent Biff his car, who then totaled it. Biff being Biff, he of course blamed the accident on George, saying George should have warned him about the fact that the car had blind spots.
I can't believe you loaned me your car without telling me it had a blind spot. I could have been killed.
Obviously, every car except maybe a convertible has blind spots, so we can all recognize that that's just kind of a stupid claim. But then he also refers to the fact that in the midst of the accident, he spilled beer on himself.
Can I assume that your insurance is going to pay for the damage?
My insurance. It's your car. Your insurance should pay for it. I want to know who's going to pay for this. I spilled beer all over when that car smashed into me. Who's going to pay my cleaning bill?
Essentially, this scene is hinting that he was driving while intoxicated, which is a much more likely explanation for the collision than just not knowing that the car had blind spots. In part 3, it seems the presence of whiskey is suggesting the same thing with the horse incident, which would imply that Buford is really at fault for all of those damages anyway. So if I were a lawyer involved in this case, I would definitely want to know more about the circumstances of that whiskey, either as Tannen's lawyer to get him to level with me before we proceed with trying to recover damages like this, or as Doc's lawyer to argue that the whole incident was clearly Mad Dog's own doing. Okay, so to tie this all up, if this case were a breach of contract case, Mad Dog is not likely to succeed because he actually never paid for the services. Second, if this case were litigated as a tort claim for Doc's alleged faulty services in shoeing the horse, Mad Dog would not likely be entitled to damages for the whiskey because that's an unforeseeable claim. Likewise, Mad Dog is likely not entitled to damages for the horse either because Mad Dog is required to try to mitigate his damages, and he did the opposite by shooting it. So all in all, if this case were litigated properly, Doc would probably actually win. And either way, I know this is super obvious, but just to round out the analysis, even if Mad Dog were entitled to damages, those damages do not go so far as to justify killing Doc for them, obviously. So there you have it. Are you surprised we landed this way? Are you not surprised? You're probably not surprised. Either way, let us know in the comments below. Anyway, I hope you guys enjoyed this video, and if you did, we'd love it if you'd like, comment, and share. And if you're new here, or if you've seen a video or two and haven't done it yet, go ahead and hit the subscribe button and the notification bell so you can find out when the next video is uploaded. Thanks.